Does this suggest that the law is different, or the law is what anybody says it is and doesn't have one particular definitive position or interpretation on matters?
Well, first, let's say the courts are composed of a number of justices at the appellate level. At the Court of Appeal is 3, at the Supreme Court 5 or 7, where it involves constitutional interpretation. But the numbers are the way they are, not even numbers but odd numbers, so that a decision can be reached. The aggregate majority decision in every panel is the decision of the panel, as is the case in every corporate decider, elections and all of them. Majority position is taken as the decision of the electorate. So that is normal, and that's how it is. Doesn't mean the law is not a single thing. No, the law is always what the law is. But when we look at the law, we may agree or disagree with some positions with respect to how they correspond with the law, a set of facts you are dealing with, and how they correspond with the law. That's why you have sometimes differing opinions. You could also have a funny situation where you even have a consensus decision, and there could still be legal doubts about such decisions. So it really does not matter. Once a majority of the panel, members of the panel, take a position, that stands as the position of the court.
Well, let's get to the main matter of discourse right now, which is the Supreme Court's judgment ruling in this particular case, declaring that Ahmed Lawan is the authentic candidate of the APC for Yobe senatorial election. And I'll just go straight to it, right to it. Is the Supreme Court ruling in line with the law?
This is one of the cases where I'm in disagreement with the decision of the majority of the panel that took the decision. I stand with the minority decision, that is the dissenting decision of the two justices that held a different view, and they held the same view. I think this is one of the cases where I am unable, as an individual, as a lawyer, therefore a citizen and a stakeholder in the legal sector, I am unable to agree with the Supreme Court on this decision.
And what would be the reasons for that?
But first, the technical reason of or the process by which it was started should have been different. I do not see anything in the law. I have not seen anything in the law that says that question cannot be raised by the means by which it was raised. The law did not limit the raising of such questions, resolution of interpretation of documents and correspondence with them. It does not limit it to only originating process.
I believe you're referring to the position of the some of the judges who said, where there is an allegation of fraud, it should not be commenced by an originating summons. I believe that's what you're referring to.
Yes, that's the position of the majority of the panel, decision of the panel, which is eventually the decision of the court in the case.
Could you start? Pardon me, Barrister. Could you start by explaining what an originating summons is and why that is a matter of contention for these judges or these justices?
Okay, you have a number of ways of commencing suits. Let's just deal with 3. You have a special procedure, the fundamental rights enforcement procedure, which is derived from Section 46 of the Constitution. You have the regular writ of summons with which you can bring any issue before the court for determination of the court. And then you have another one we call originating summons, which is better suited for certain kind of decisions, like asking the court to determine whether the provision of a law means what the applicant is saying, or whether it means what his opponent is saying that he is opposing. So for such interpretation of laws and documents, the most convenient way to use is the originating summons. But the question is, does that disqualify a course of action? Does that disqualify a suit because the most convenient or the most suitable or the preferred way was not adopted? The position of the law is not that other questions cannot be resolved. Issues of that nature raised by a writ of summons cannot be answered by the court. That's what I said. I'm unable to see anywhere where the law says so that such questions cannot be determined unless they are raised by originating summons. So that I am unable to agree with. That's at the beginning. But there are more fundamental issues. You have provisions of the law that clearly say a person, a political party, cannot change its candidate once it has conducted primaries and a candidate has emerged. Only a candidate who dies may be changed by the political party. The law allows for that, where a candidate dies or where a candidate decides not to participate in the election, where he abandons the process and resigns or decides that he's not participating. If he pulls out, the party is at liberty to notify INEC and thereafter within 2 weeks conduct another primaries. So except in those two situations, the law says a party cannot change a candidate after one has been picked. So how do you explain the fact that the political party involved conducted primaries and somebody won that primary, duly conducted with all the requirements of the law, including the participation of INEC, and somebody was returned as winner? So how do you dispense with that primary? Because in law, you can no longer hold another primary so long as that one stands and the winner did not resign or withdraw or die. You cannot hold another. So how does the Supreme Court position explain another primary was validly held from which the winner, according to the emerged? Because the implication of that is that an unquote winner was not participant in the primary that was valid, that was not declared invalid, and that was not set aside. So how do you win from a process that he did not participate? That is one part. If that was conducted, was it valid? That is a valid one that has been conducted, and according to the law, the political party has law right to conduct another or nominate another person. We still have a very critical issue that this gentleman participated in the presidential primary of the political party in the same election, and the law says the thing cannot be eliminated in political party. How does the court explain the fact that this one, whose name is on record and on record, and also in the
pardon me, we'll have to go for commercial right now. We're shortly to please us. Welcome back to Hard Fact to Nigeria Info here in Port Harcourt, the number one talk station. I'm Dio. 28 minutes gone past 4 p.m. Let's talk. Machina loses as Supreme Court affirms Lawan as Yobe APC senatorial candidate. The cable story from the cable. I'm asking you once again, the Supreme Court's judgment on this matter, does it constitute an upholding of the rule of law and justice in your estimation? Join me live on Facebook and Twitter. YouTube as well at Nigeria Info PH. My guest once again joining me via phone, Barrister Wokocha. Barrister Wokocha, you're welcome back.
Thank you, Dario.
Before the break, you expressed that you disagree with the majority decision of the Supreme Court, as three of the justices granted victory to Ahmed Lawan. Two, however, dissented, saying or agreeing with the position of the Court of First Instance and the Appellate Court that Machina is the rightful candidate. And you were explaining why. You were on the third point before the break. Please go ahead.
Yes. The third point I was raising was that the Supreme Court cannot explain how a person who participated in the primaries for presidential election, again qualified to participate in the primaries of Senate, although we know that he did not participate in the senatorial primaries, because at the same time he was participating in presidential primaries, so he did not participate in the primaries. So, I mean, how does the court explain these three positions? That a person who did not participate in the primaries that was valid was declared winner. How did he emerge from the primaries in which he was not a participant? And secondly, how did he become a valid nominee from a primaries that was held after the valid primary of the party has been held, in a situation where the law said the political party cannot change candidates? Their candidate did not die, he did not resign. So how did the party acquire the validity to hold another primaries from which the quote-unquote the said winner emerged? So these are the irreconcilable facts, both in law and in fact. That decision is very questionable. It's in fact unexplainable, because it does not know the law. Those terms of the law that is offensive. I mean, two injustices said, they find somebody who did not participate, who was allegedly in a second primary head that they has got the power to primary, hired one from which somebody emerged. Those are very level questions. Trying about decision, very questionable and disturbing.
Well, I'd like to read one of the judges who gave victory to Amman. I'd like to quote now, and specific Justice Isay, the suit shows the allegations of fraudulent practices against the applicant. That the first respondent accused the APC of fraudulently substituting his name with that of Lawan. When the allegation of fraud did not come by a written summons, there was a need to call witnesses to prove allegation of fraud. What are your thoughts?
I think that change on the justice now. The element in the claim we think could not have been validly raised under this procedure. What of the elements were valid under adopted? And even if you put that, I said at the beginning, aside the fact of process that was related, was the candidate declared participant in the process? Could he be have emerged from the electoral act process done by the electoral act? Could he be spent in it? How does some elements disqualify all the other elements that were not part of the some elements?
I'm going to invite the man argued towards the judgment of appeal. I affirm the judgment of the court as to the appropriateness of the use of originating summons. Let's talk about the originating summons and how that, even if it were deemed inappropriate, really have to do with the fact of the matter. I'm struggling to deal with the contention whether it is not appropriate to have used it. So three justices said it's not appropriate to have used that, and two supposedly are saying that an originating summons was very much appropriate in this scenario.
Exactly. Whether was used or not, or whether some element in it was one that would have been determined to originating summons, did not affect the validity of the rest of the suit. The rest of the issues that were raised in the suit, the questions that were raised, it did not touch them. So that could not be basis for throwing out the entire suit. Are we saying that if we run through the judgments of the Supreme Court in previous cases that they did not take decision on cases that were commenced by the same means that this one was commenced. It's neither here nor there, but as I said, we avoid using
on July. It said the party did not cancel the May 28 election before going ahead to conduct another primary election. The justice also noted that INEC was absent, did not monitor the June 9 election, and, quote, the appellant has not contradicted the findings of fact are perverse or unreasonable. The failure to challenge the findings of fact defeats the entire appeal. So, can the court, the Supreme Court in this case, decide on the matter completely with complete disregard for what the facts of the matter are? And if it can do that, on what then does it place? On what foundation does it place its decision if it completely
and determines on which set of facts, which of the contending contentions is on the side of the law? That's why a judgment must always be based on the law. So that is why I ask the question, how can the Supreme Court arrive at that position, as the dissenting judgment has said, in the face of all those evidence? Now, you are talking of not giving appropriate notice, which is going to the validity of the second primary. The question is, can there even be a second primary when the party has exhausted its right to hold primary, and the condition for holding another has not happened, which is resignation or withdrawal of the candidate that emerged from the process? The judgment is riddled with unanswerable questions that definitely create serious doubt in the mind of a member of the public. I don't think you need to be a lawyer to have questions in your mind as to the validity or as to the appropriateness of the interpretation given by the Supreme Court in this case.
Now, since there are question marks as to the validity or the appropriateness of this decision on the Supreme Court, is it still final then? In spite of the question marks and the contentions surrounding this decision of the Supreme Court, is it final?
The fine gentleman, the jury CEO, told us long ago that the Supreme Court is Supreme Court, and we should expect that his decisions are final. We shouldn't deceive ourselves by thinking that because his decisions are final, that they are infallible. And he explained to us that they are human beings, and they are also subject to mistakes and other things that happen to human beings. So their decisions could be fallible, but because they are a Supreme Court, their decision is final. You can't resist it. You can't protest against it. There is no valid legal way of objecting to the decision of Supreme Court. You can criticize it. You can exercise the right of citizenship and your freedom of expression to criticize it, to raise questions the way we are raising, to doubt its appropriateness. I believe those criticisms are not useless, because if they are well established, when the Supreme Court comes by the same scenario in the future, it can take a different position that accords with the law. That way the previous one would have been overruled. The decision is final, and everybody is bound to obey it, notwithstanding that it's a very fallible decision, riddled with holes of doubt.
Has it ever happened? Has it ever happened that the Supreme Court is represented with a decision that it has made and asked to reconsider it? And can that happen in this case?
On a few occasions it has, but the conditions for that happening are not these issues that the justices have considered and arrived at decisions that we think are inappropriate. Those ones arise, for example, one of the grounds is where there was an obvious mistake on the fact relied upon by the court, or where there was a fraud that renders the decision of the court one that endorses or establishes or sustains a fraud. It still goes to the facts, meaning that the condition of facts upon which the court court arrived at the decision turned out to be different from those which the court believed it was dealing with when it arrived at those decisions. So, yes, it's usually possible, but not on this kind of ground, not on the ground that your legal consideration of the issues it dealt with was not properly done. I want you to look at it again. Then litigation will be endless if that is permitted. So that's why that is not done. It's only in those clear cases, as in the examples I gave, that the Supreme Court may be urged to revisit the matter.
Is this case not clear? Is this case not clear enough?
Well, this case is different because the facts upon which the court arrived at the decision were clear. Those are the facts that they clearly considered and yet arrived at the decision we are saying are wrong, and their colleagues, 40% of the panel, maintained the same position, clearly that position taken by the majority was wrong. So it's different from where they thought that the man participated and they reached a decision believing that he was part of the first primary and he had the highest vote. And the facts emerged that indeed he officially withdrew from that process and did not participate. When you have that kind of situation where there is new fact emerging showing that he actually wasn't there, meaning that the set of facts upon which the court arrived at the decision were wrong or were different from what the actual situation was. You can see that that can be distinguished from this situation where the court, let me put it in this clear way, with its eyes open, clearly with its eyes open, jumped into that doubtful decision. There was nothing, it was not blindfolded, there was no different sort of facts, there was no deception, there was no fraud that led the court into reaching that decision. This decision was reached by the court by itself with its eyes fully open.
Does this decision of the Supreme Court set a precedent?
Yes. It sets a precedent. In fact, every other court is now bound, as it were. So without the National Assembly going to work, the Supreme Court has practically amended the Electoral Act. Because every other court can rely on this decision in cases and set of facts, cases in which the set of facts corresponds with the set of facts here. Notwithstanding whether it is a governorship or it is a House of Assembly or any other kind of primary. As long as they are dealing with this situation, a court can now rely on this decision and rule that somebody who did not participate or who has participated in a different thing, maybe the governorship, is the person that emerged from House of Assembly in the same election season. They cannot rely on it. It sets precedent.
Join the conversation right now, if you will. You're welcome to do so. Do call 070-093-093. We're live on Facebook.com/Nigeria Info PH. We're live on Twitter as well, at Nigeria Info PH. Let's get your take on this development at this time. Once again, number to call 070-093-093 via Facebook and Twitter at Nigerian for PH. Via Twitter at Real Rivers King tweets, why is Professor Wokocha still an associate professor? Is about the best legal mind at the Faculty of Law, Rivers State University, and one of the best constitutional law scholars in Nigeria. Barrister Wokocha, apologies if this puts you on the spot, but he's asking a question. Why are you still an associate professor?
Okay, because I have not taken any steps to move to another level. You must first, sorry, this is outside our discussion, but you must put in for appraisal before you are appraised. I have not considered it necessary to do so.
All right.
So it's not anybody's fault. It's my decision taken with my eyes fully open.
Okay.
The judgment we are discussing.
Noted. 070-093-093 via Facebook. D'Antonio Pedro goes, Nigerian judiciary keeps disappointing Nigerians. Even law students in RUST can give a better judgment. All right, let's go to the phone lines. Hello, Hard Fact. You're welcome. Please go ahead.
Hello, Dayo. Good afternoon.
Go ahead, please.
Hello.
Hello, Hard Fact. You're welcome. Please go ahead.
Good afternoon, Dayo.
All right, go ahead.
I'm calling you from Oyibo, William.
Go ahead.
You see the level of injustice in this country. The judiciary is one problem we are having in this country. Because this thing is an obvious judgment. Ahmed Lawan, like I know, he said he was not going even to contest this matter in the law court. So I wonder how they can just turn over this judgment in favor of him. So if this judgment cannot be reversed because it has been given by the Supreme Court, then this is injustice of the highest order. That is what I call it. We cannot. The system is so corrupt that you will see white, you will call it black. One will see white, will call white to be black. It's so hard disheartening. Thank you.
You're welcome. 91.3. Hello, you're welcome as well. Please go ahead.
Hello.
Hello, go ahead, please.
Hello.
Hello, you're welcome. You're live on radio. Go ahead.
Hello, can you hear me?
All right, moving on. Immaculate in Wanzuma goes, judiciary is no more the hope of a common man. Judiciary is monetized, taken by your own judgment. Hello, Hard Facts. You're welcome. Please go on.
Yeah, and I've been following your discussion, but I'm a little curious, and probably this is for Barrister to clarify. The justices said this particular case was supposed to have been presented in a certain way, but it was not presented in that way. Is it possible that those impacted can go back and present it in the way the justices want for the consideration? That's the question I have, I guess.
All right, great to hear from you, sir. Barrister Wokocha, he's asking, since three of the justices said the problem is originating summons, and there is a more appropriate way that the matter should have been instituted in the first place, can they go back and represent the matter in a way that will please these justices? Is it possible?
Apparently, that would be against the rule of double jeopardy. You cannot bring a suit on the same set of facts that have already been litigated and a decision given. You cannot.
All right.
So you can't go back and start it afresh between the same parties on the same subject concerning the same set of facts. No, the Constitution says no.
Oh, hello, Hard Fact. Welcome. Please go ahead.
Yeah, good afternoon.
Hi, go ahead.
It is very obvious and crystal clear that the judiciary are the worst enemies of this country. How can you do something on nothing? Eh? How can you do that? Now, the lower court on their wisdom decide that what this man did is wrong. Then you, the Supreme Court, are supposed to even correct the mistake of the lower court. You are the one making the blunder, the greatest error. Where are we heading to? It's so unfortunate to, whenever I see things like this, I weep for my country. It is where the man has nothing to do. The Supreme Court has said it all. So let him take it by faith.
All right. Once again, join in Twitter, Facebook, Nigeria Info PH. So, Barrister, no doubt this is a very contentious matter. I mean, something that appears crystal clear seems to have been turned on its head by the Supreme Court. Is that where it ends? I mean, I know that for judges in lower courts, if there is a suspicion or an allegation of impropriety on their part, a petition can be filed at the NJC, and investigations will be conducted. And if they are found to have, perverted justice in any way, sanctions can and are meted out against them. Is that possible in this case with justices of the Supreme Court?
Justices of the Supreme Court are still judges disciplining over the judicial officers. It's applicable to them too. But you have to have a case of establishing the fact that something inappropriate happened, not that they did not properly evaluate the law or their reasoning and understanding of the law that the judge done did not appear to have been proper. You can only raise question of discipline if something that is inconsistent with their oath of office, something that runs contrary to the code of conduct and to their judicial creed is done. For instance, the usual corrupt activities of corruption that you know. If you found money movements from the account of a party to a judge and all that kind of situation is the only thing you can complain about, but not how well put or how well they appreciated the facts in decisions that they reached. No, those are not subject for disciplinary issues.
All right, and Kenneth only on Facebook goes, it's a pity where we are on the judiciary's independence. Let's get your take as well. Let's see. Via Twitter at Richie Walker goes, EFCC, ICPC, National Assembly, Supreme Court, CBA, National Orientation Agency, ASU, NNPC, Army, Police, etc. The Buhari regime destroyed every institution of state. The APC spared no expense. Is there any institution left? Where is Nigeria heading? Who brought this crisis? Hello, hard fact to welcome. Go ahead.
Okay, sorry. You are still on the Lawan case. Good. I am very, very disturbed about how we Nigerians judge things. I'm talking about this from the experience I got from the Imo State case. Are you hearing me, sir?
Go ahead, please.
Okay.
And make it quick.
I do not know the man, the present governor. He was the first person, and the Supreme Court made him the governor. I was very angry, but I decided to go deep into that case and discover that the Supreme Court was perfectly correct. So when I heard about this one too, I started listening to views from lawyers. And they came to make me understand that the Supreme Court does not just dash you justice. It's what you go with. The case the lawyer went with was a criminal case. As in, like, somebody signed my signature without my permission. Let me put it that way. He was not saying he was the rightful person. So let us go back to that case individual before castigating the judiciary, because sometimes I put myself in that position of the judiciary and it's like Nigeria can just kill immediately. We know that, yes, Lawan didn't contest.
Pardon me, I am really pressed for time. I can only take so much from you. I have to wrap up the show right now, but thanks for your contribution. We have to wrap it up. Thanks for joining in. Thanks to my guest, Barrister Wokocha, an associate professor of public law, Rivers State University. Barrister Wokocha, many thanks for your time, as always. Got a commercial break coming up. News update at 5 o'clock, and we're discussing the propensity for electoral violence in Rivers State. Please stay with us when we return.
The show continues after this break on Nigeria Info.